Hi guys, Brian Fell here, Fell Law Group PLLC. Came across a few cases in the Florida Law Weekly that I found interesting. I'm an avid Florida Law Weekly reader, so I figured if I come across something that's interesting to me, I'll share it with you guys. So the first case that I found interesting this week is KMG Properties LLC versus Owl Construction LLC. And let me tell you, it's a real hoot. That's an owl joke. So basically, this is a service of process case, and it had to do with serving an LLC. And the process server served an LLC's registered agent at the location of the registered agent, but what they did was they served the administrative assistant at the front desk. And so Owl Construction was trying to argue that because the administrative assistant was not really an employee of the registered agent, that service of process was not properly affected, because they were saying that the person had to be an employee under the statute. And so the second DCA said, no, you don't have to be an actual employee of the registered agent. You just have to be a representative of the registered agent. And because the administrative assistant basically said that the registered agent was there, but just wasn't available at the time, and because the registered agent basically held herself out as a representative of the LLC, service of process was properly affected, even though she's not an employee. So that's important, because if you have somebody that's working the front desk, or maybe you're in a shared office space or something like that, and just because the person is not your employee, they could still potentially be served with process, and then that process could be binding on you. Let's say you're there in person, you're in the office, and somebody comes and serves an administrative assistant who's acting on your behalf in a representative capacity. That could probably be proper service depending on the circumstances. So that was an important case for me to talk about. And then the next one is a case out of the third DCA. It's a family law case, Tina Sieberg-Shabbick versus Michael Shabbick. And the reason I found this one interesting was that it had to do with pleading affirmative defenses of set-off. So there's the whole saying, if you don't plead it, you don't get it. Well, this was an affirmative defense of set-off for credits for payments for the marital home. Essentially, the husband was trying to say he should get a credit for the fair market value of the rent, the fair rental value of the marital home during the time apparently he wasn't living there. And so for his divorce final judgment, he wanted to get a credit, an offset or set-off for that amount. And so apparently he was awarded the credit, but the wife appealed, and in part she won because the husband never pled set-off as an affirmative defense. So the court said, third DCA said, hey, you didn't plead it, you didn't file a motion for set-off or offset or anything like that. The only time that it came up before trial was in the husband's pretrial catalog. That wasn't good enough. So make sure, if you're trying to get a set-off for the fair market value of rent or anything like that of the marital residence, make sure you plead it as an affirmative defense, or at least file a motion, because if you don't do either one of those, you may be out of luck and you're not going to be able to get that set-off affirmative defense. And so the last case that I came across was an alimony case in part. It's Catherine J. Duhamel versus Gerald E. Duhamel. It's out of the second DCA. The only reason I thought this was interesting, it had to do with need and ability to pay. And the court found that $2,500 a month alimony for the wife was insufficient to cover her need, and the husband had the ability to pay. But the reason I thought this was interesting was that it's an older case, and it applied the older alimony statute. And so now that it's on remand, now that we're in 2024, it's on remand, is the trial court supposed to follow the new alimony statute with the new guidelines, or is the trial court still going under the prior alimony statute? I thought that was an interesting issue. There may be an easy answer to that. I just don't know it, but I thought it was interesting. It's an older case. It started in 2015 and has an interesting history, but basically there was an amended final judgment in 2022 before the new alimony statute came into effect, and then now it's been reversed on appeal, and so the trial court's going to have to determine alimony in 2024. Does it apply the new alimony statute? I don't know. I'm not sure. Maybe you guys can let me know. All right, thanks.